and welcome to a beautiful Saturday afternoon. This is Bethea'S Byte Reloaded. I'm Ernest Bethea, the Last Outlaw. Welcome one, welcome all. Man, today is a loaded day. Most of it, as I've mentioned when I first scheduled this live stream, a good portion of it has to do with the Alec Baldwin Manslaughter Trial, but I'm going to go ahead and condense that down to just one moment, and that was the moment that occurred yesterday. But I'll break that down later. Right now, as always, I want to bring a missing persons case, but it's not just one person today. It's three. It's an entire family. Let me direct your eyes to the screen real quick. All right, this is Abigail Bernstein. Her daughter, or am I looking at the son here? That's the son, Courtney Bernstein, and daughter, if I'm pronouncing her name right, Chloe Bernstein. All three are missing as of October 2022 from Alawai Boat Harbor in Honolulu, Hawaii. Now, the details are kind of limited, but I'm going to give you everything that I can give, so please pay attention. The FBI in Honolulu is seeking information regarding Abigail Bernstein and her two children, Courtney Bernstein and Chloe Bernstein. The family was last seen at Alawai Boat Harbor in Honolulu in October of 2022. The Bernstein family has ties to Naples, Florida, Petoskey, Michigan, Lancaster, Pennsylvania, and Hawaii. There's no information regarding heights, weights, or anything of that nature. But I will go through this and say simply end it by saying, if you have any information regarding the Bernstein family, please do not hesitate. Call 911, or you're asked to call the FBI's Honolulu field office. That number is 808-673-2719. 808-673-2719. You're also asked to call, if you have any information, you can also call the FBI's toll-free tip line at 1-800-CALL-FBI, 1-800-225-6324. Or if you want to send in your tip anonymously, you can do that too. The address is tips.fbi.gov. Tips.fbi.gov. Any information you can send in could be the difference of finding all of these family members, and or they could be found any other way. But still, get in contact with one of these agencies and let them know that you have information that'll be another step to bringing that family home. Remember, as always, if you see something, say something so we can do something. All right. Also, I do have some good news to share in out of missing persons. So let me pull this up real quick. Right. Okay, there we go. All right. If you are looking at your screen right now, no, that's not it. That's not it. Hang on, guys. I'll tell you what. Let me play this by process of elimination here. There we go. That helps. All right. All right. Here we go. I did say I have good news regarding missing persons, and I do. The young lady on your screen, Elizabeth Gonzalez, she has been recovered. Elizabeth Gonzalez has been found safe and sound, thank heaven. So this is good. She was recovered out of where she was missing in Mexico City, Mexico. So thank God for that. Let's find another missing person. All right. All right. Let's try to find that family and bring them home. Right. Okay. I am going to start off with an update in the Karen Reed mistrial. Alright, here's what we know. That Karen Reed wants 2 charges dismissed and says that jurors were unanimous. There's a bombshell new filing in from the Karen Reed defense team saying that the jury had unanimously agreed to acquit her of the 2 most serious charges she faced before a mistrial was declared. Karen Reed was charged with second-degree murder, motor vehicle manslaughter while driving under the influence and leaving the scene of a collision causing injury or death, and stood trial for more than a month. The jury deliberated for more than 24 hours over 5 days before Judge Beverly Clenney declared a mistrial on January 1st. On this past Monday, Karen Reed's attorneys filed a motion to dismiss 2 of those 3 charges. Here's the breakdown on that.
Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Santa Fe, New Mexico, covering the Alec Baldwin case. But we want to switch gears momentarily here for some breaking news out of New England and the state of Massachusetts in the case of Karen Reed, the one we just finished up here on Court TV. The defense has filed a motion asking for 2 of the top charges against Karen Reed to be thrown out. And the reason they are asking it in this motion that they filed is because it has come to their attention that the jury had a firm 12-0 agreement that Reed was not guilty of 2 of the 3 charges against her, including that top charge of second-degree murder. According to Alan Jackson and David Yannetti, the lawyers, of course, representing Karen Reed, who filed this motion, they say that jurors got a hold of them after hearing reports about the supposed juror split. We've heard all kinds of things. If you've been on social media, people are saying, oh, it was, 6-6, or it was this, that. They're saying that jurors reached out to them and that the jury had unanimous verdicts of 12-0 on the top 2 charges. But apparently, what I'm reading here is they didn't put it together that they could have come back with those verdicts and said not guilty, and hung on that 3rd count. Let's bring in Jessica Ehrlich to discuss this. This is interesting, Jessica, because, we got the jury coming into the courtroom saying we are undecided. We can't come to a unanimous decision if this is true. does the defense have a solid motion here to basically dismiss these charges? Because if indeed the jury was in agreement 12-0, they effectively came to a verdict on those top two charges.
Yes, I mean, I'm dying to get my hands on their motion because I would really like to see, from a legal analysis standpoint, if there are precedents in the state of Massachusetts that they're able to cite to in this matter. I mean, it's certainly from a public policy standpoint, we know that, for all courts across the country, you always want to have, especially after a lengthy trial like this, and it's been to the jury, it behooves everyone, and it is sort of the public policy standpoint, that you want the jury to at least come back on one or two of the issues, so that to avoid a mistrial. You really want to do everything you can to avoid the situation that we had here when they had a hung jury. So I definitely think from that standpoint, it's a very strong argument to make. The question is, in terms of Massachusetts, will the judge be able to call the jury back and feel that they're able to take this vote given everything that's happened since they were dismissed. So it will be very interesting to see. I mean, definitely quite a turn of events here. I mean, we've been following this for a long time, as you know, and it is fascinating, and actually does not surprise me at all that the jury did have very strong opinions about those first two. And you and I were talking when remember, there were so many issues with the jury instructions in this case that we knew that something was going to happen for sure. I mean, this was just very confusing for the jury. They had to redo the forms. So really, I'm not surprised that the jury came back on this. And it's very interesting that the jury actually reached out to the defense on this. I'm also curious as to how that transpired and what was going on there, that conversation was had.
And there has been so much misinformation because of the interest levels and the different bloggers that have jumped into this full force. It'd be, in terms of a remedy here, if the court really wants to find out, you don't just go by what the defense says, obviously, and you can't really just go by with what 1, 2, 3, or 4 of the jurors told the defense. Great, juror number 4 believes that it was 12-0. Don't you have to? Doesn't the court have to do a full investigation and contact all 12 of those sitting jurors to validate this claim from the defense, and then make a decision after establishing that this is in fact true?
Well, it'll be interesting to see how they, wrote their argument. I think certainly the judge would speak with the foreman, because really the foreman is supposed to be the spokesperson for the entire jury. So if the judge speaks to the foreman, if they even go that far, I mean, I don't know that it's really a matter of saying, is what the defense saying true? It's also a procedural thing. Can they even bring the jury back after they've been dismissed? Would this even be allowed from a jurisprudence, procedural Massachusetts law standpoint, to even whether the judge would be able to interact with the jurors on that matter, whether the court would. I mean, this is a very unusual situation, but I would say definitely they would start with the foreman, because the foreman is supposed to be the spokesperson of the entire jury body. They were elected by the jury, and they should be able to sort of speak to that. Now, I don't know whether in the motion the defense spoke to the foreman, and the foreman was the person who said, we had a unanimous decision on the first 2 counts, but could not go further, and didn't realize and didn't understand that that was possible for us to make a decision on. Because also there should be notes and everything kept by the foreman as to what actually transpired. It's just a very, very unusual and difficult situation. I mean, I can see why, from a public policy standpoint, it is what you want to avoid, having to do this entire enormous trial over again on all counts. But I mean, I'm dying to read.
But was it really a verdict? If they told the judge that they could not come to a verdict, was it a verdict? They may, if what they're saying is true, if what the defense what they got from these jurors is true, that they all agreed 12-0. All right, definitely not murder too. Definitely not intoxicated leaving the scene of the accident. Then they should have put that down on the verdict form, and that those were verdicts. Absolutely. Correct? And that's a mistake possibly from this jury. But how do you remedy that?
I mean, I think that is the ultimate question. And it's certainly going to be a matter of law and precedent. I'm not sure that there's a lot of precedent in Massachusetts that I'm aware of that would actually give the judge a lot of room here in terms of where to go. I mean, I know even with some of the issues with the form, it was unlikely that they were going to change the form. Then she reviewed the various arguments and came back. So this is really sort of one of those arguments. Certainly, even if the judge says, no, the jury was dismissed, this is something that, they can try to bring up, I think, in their appeals and in everything else, that this was, a tainted trial from the get-go, and especially given the fact that the jury was confused as to what their instructions were. We know that there was confusion around what the form was, and that led to the situation that they were in, and therefore it should be, tossed out. So I mean, this is going to be a really interesting, I'm dying to hear the arguments on this.
Yeah, and just reading parts of this motion, it's not clear that they have definitive evidence. They're getting it from a juror that reached out after seeing inaccurate reports in the media about the split. And there needs to be, one would think, more investigation before a judge can do it. There's Judge Ashley Wilcott. She knows what to do in a situation like this. First of all, Judge, your initial thoughts reading this motion. Wow. What should be done here?
Well, first of all, the right thing to do by the defense is to file a motion like this if they have information to believe it's true. But Ted, can I just tell you, the thing that bothered me the most at the end of this trial was nobody asked to poll the jury. This, from a judicial perspective, is why you have to ask to poll a jury, because if they'd done that, they would have known right then and there to figure out what to do next if, in fact, 12 said not guilty of the higher charge. So I don't know the law. I haven't yet had a chance to look at the state law and this state case law, but I would want to look at, if you don't pull the jury, do you waive any right to raise it down the road? You might. So there are a lot of legal issues. But again, all I can say is, why in the world would you not poll a jury to address this at the time it was happening?
And normally, when a jury comes back and they cannot come to a decision, a mistrial is declared, it's not, on the record in the courtroom polling, what'd you think, what'd you think, what'd you think, because it's a mistrial. But to your point, typically, after the dust settles and both sides want to know what the split is, right? Especially the prosecution. Are you going to retry this case? Well, how about finding out what the split is? And it doesn't seem as though that was done. And now we're in a position where you have a juror contacting the defense saying, I was watching the TV and they had it wrong, or I was on social media. That wasn't the split. Jessica, again, do you have to do a full investigation before you can even think about another step? Because if this isn't accurate, well, then there is no next step. But if it is, boy, it's a head scratcher.
I mean, I think, to the judge's point and what you were saying a little bit earlier, to loop on that as well, one of the reasons you're polling the jury afterwards too, from being the advocate standpoint, is what are your arguments that landed well and where were there maybe missteps? So if you do have to retry this case, to improve, to tighten, all of those sorts of things, where the holes are, not to mention the situation that you're in now. So certainly, I have to go back to the foreman of whoever this is. We don't know. I haven't looked at the motion yet to see who it was. You can't make legal decisions based on what is complete hearsay and gossip, right? We know this in general. However, there are, and certainly, I think the judge will be aware, the larger argument here, I don't see way that they would necessarily reach out to every single juror before they make a ruling on this motion to say whether that is true or false. The question would be, I think put to the foreman at first of, did this situation occur? Was there a vote on this count? And then it was unanimous. Was there a vote on this count? Where are the records of that? Where is everything of what, that they had as to what they actually voted on, and to how they interpreted and how the foreman interpreted the form at the time?
Judge, Ashley, your thoughts on that and what you think should be done now at this point. And another question for you. Isn't it up to the judge at the end of the day to have gotten this information, to facilitate the conversation between the parties and the jurors after a mistrial was granted?
Yeah, well, I just wanted to comment on that. Ted, as the judge, honestly, you always have to look at the verdict form to make certain that it is correct in terms of how it's filled out. So arguably, this judge knew that it was 12-0. If in fact it was, we don't know confirmation of that. We just know that's what's in the motion that a juror has said. But the judge should have looked at the form of the verdict, and I guess I wonder, under the laws in that state, again, case specific, should the judge have said, all right, we've got a problem here because this is a not guilty. This is not a hung jury on these charges. So that's point one. Point two is, Ted, you're absolutely right. Two things. Number one, the jury could have been influenced by now because they've seen everything, heard everything. So how do you know when they come back and say, oh no, we all said not guilty? Has there been any bias? Has there been any changing of minds because of everything they've now heard? Number two, a judge can never make a decision without evidence on the record, period. Legal arguments, evidence on the record. So no matter what, if the judge is willing to consider this, my opinion is there has to be an evidentiary hearing.
Oh, yeah, for sure. And, I think they didn't fill out the form. I think they thought that if what is being alleged here by the defense in this motion is true, I think they got back there. They were going through it. All right, we all agree this is it. And then they're like, oh, gee, we can't get them all. This is a mistrial. We can't. There was a misunderstanding there if what they say is true. But that's the big one. If it is true, we'll have. So Judge Wilcott, if you were in this predicament now, do you bring all the parties in and, to Jessica's point, bring the jury foreperson in to get some clarity?
I think almost you have a hearing with attorneys only to determine, is there merit? Does it need to go forward? And then if you determine under the case law, under the legal arguments, that you then do need to have a hearing, which I would suggest she might, then you do bring in, you have to bring in evidence. So you're going to have to ask the jury. And the alternative, the first thing I would do as judge is go back and get those verdict forms. Right, Ted, to your point, let's see what they say. Was there a misstep by the judge if in fact it reflected that it was 12-0, 0-12, and therefore should have been an acquittal on those charges? A lot of homework this judge has now.
And if it's true, Jessica, if you're Karen Reed, hey, I'm crying foul. I mean, the jury voted 12-0 on the top two charges. Cut me a break. This would be double jeopardy if you try me again.
Yes, and we know this will go, directly to everything that the defense has been saying from the get-go, and that they said, as we know, because, I was on with you when we were going back, and the judge at first said the form is fine, then came back and changed the form. The jury was out. She had to go back, and she said no, after reviewing it, that she did feel that there were some typos and some various things that needed to be changed on it. So we know that there were issues around this from the very beginning, and clearly there may have been some issues. I think the judge and I both agree completely that I don't know in the state of Massachusetts if there is precedence for this as to what the steps should be next, but certainly this is a boon for the defense regardless of whatever happens next, because we know that whoever will be in the next jury pool for whatever happens going forward, everything around this, doubts are sown from the get-go now going forward.
Yeah, absolutely. In a case that was already a powder keg of emotions in this community, it's just going to explode now. The Free Karen readers are going to be out in force if they do recharge or try to on the second-degree murder for sure. Again, the breaking news at this hour, Karen Reid's defense filing a motion saying they've heard from a juror that claims that they were in agreement on the top two charges. 12-0 not guilty, but it wasn't reflected in the mistrial because they came back to the court saying we couldn't come to a unanimous decision. Yet might they have already on those two charges? They should have written that down. Those were verdicts, if indeed all 12 agreed.
All right, thanks to Ted Rollins regarding that breaking news. Judge Ashley Wilcott for her legal expertise as a judge, and I gotta agree because I followed a number of criminal cases since I started my journey into true crime, and even with a guilty verdict, they always ask both attorneys, do they want to pull the jury? And most times they do. Ooh, and they'll always call that juror by number, asking if that was and is their verdict. They only have two ways to answer: yes or no. Recently, I heard a lot more yeses than I've heard nos. Oh, so. That's one thing they should have done. They should have polled the jury in that. So I've got another Karen Reid update a little bit later. So stay tuned, stick around. I've got more coming. Right now I'm gonna move onward to the Brooks Houck case. It's the Crystal Rogers case. Brooks Houck is asking for separate trials in that case. All right. Instead of going through the entire motions hearing, here's the breakdown. 9 years after the disappearance of Crystal Rogers, Brooks Houck is back in court. Brooks Houck is Crystal Rogers' ex-boyfriend, and he's charged for her murder. Stephen and Joseph Lawson are also facing charges of complicity to commit murder in relation to the case. In court, Houck's attorney argued that their cases should be tried separately. Houck's attorney said his client shouldn't be tied to the Lawsons since a judge recently ruled that Stephen Lawson gave conflicting details in police interviews. The judge ruled that Stephen Lawson did not live up to a deal for immunity and will still face charges. The trials are set to be held in February and will not take place in Nelson County. That's in Nelson County, Kentucky. The judge also announced at today's hearing that he will wait to hear from Joseph Lawson's attorneys on July 18 before making a decision as to whether the trial should be separated or not. So basically we want to wait and see as to how that how that one will play out. All right. I had good news in the missing persons case earlier. I've got another one that's a little bit more high profile, and yes, this results in good news. A little more like good news than bad news. So I'm gonna go ahead and take this all the way to Judge Ashley Wilcott and Michael Ayala for this breaking news.
All right, we're going to step aside here because we have some breaking news coming into our newsroom. The search for a missing 2-year-old girl from Washington has come to an end. Over the weekend, Seraya Aung Harmon was safely located at a roadside checkpoint near Santa Ana, Mexico. Seraya's father, Aaron Aung, failed to return the little girl to her mother on June 3rd. Aung's fiancée, 21-year-old Nadia Cole, was also reported missing and was believed to be traveling with Aung and the little girl. Well, all three were found safe. Aaron Aung is currently being held in the Santa Cruz County Detention Center in Nogales, Arizona, awaiting extradition back to Washington on an outstanding warrant for custodial interference. Cole was deported back to the United States. Now, Seraya is now in the care of Arizona Child Protective Services, and we will continue to bring you any information as it comes into our newsroom. All right, let's get in that break now. We'll get you back to more arguments in the emotions hearing in the Alec Baldwin Manslaughter case when Court TV Live returns. Right here on your front row seat to justice.
Thanks to Michael Ayala for that piece of breaking news. And when I first heard about the case, I was already in prayer that that little one would be found and found safe. Guys, if you're a believer like I am, then you know the old song. He's an on-time God. The one thing that song tells you is that he may not come when you want him, but he'll be there right on time. He'll answer your prayer right on time. He sure answered this one. That little 2-year-old Seraya was found safe and sound, but nobody expected that. Actually, they did. That Dad would be charged. Custodial interference at the very least. I'll keep an eye on this case as it goes forward, and we'll see what awaits for little Seraya. All right, let's see. I'm not gonna go crazy over the Alec Baldwin news just yet. Just wait to the end. We're going to move onward to ex-football player Daniel Muir and his wife being denied bail after their missing son was found. All right. On the right side of your screen is Kristen Muir, and on the right side of that picture is former Indianapolis Colts player Daniel T. Muir. Here's the breakdown of this article from Scripps News Indianapolis. A lawyer for a former Colts player says he's being illegally held in Indiana's Cass County Jail. Daniel T. Muir faces charges of obstruction of justice and domestic battery after his missing son was found at his Logansport home. His wife, Kristen Muir, was arrested on charge of obstruction of justice. 14-year-old Bryson Muir was released to the care of the Cass County Department of Child Services. Daniel and Kristen were both denied bond, with Daniel cited as a flight risk according to a Cass County judge. The judge also issued a no-contact order between the parents and their son. On July 8th, Daniel's lawyer filed a petition for writ of habeas corpus, stating that his detention is unlawful. The lawyer said that denying Daniel bail was unconstitutional under both state and federal law. He is calling on the judge to set a hearing to set bail and allow for Daniel's release. The son of the former Colts player was missing for 2 weeks. A silver alert was issued for the teen who was last seen leaving his grandma Cheryl Wright's house in Ohio. According to court documents, Wright noticed the teen had a black eye as a result of a punishment from his father. The teen's uncle recorded a phone call with Daniel asking why the teen was in trouble. Daniel made allegations of inappropriate behavior by the teen and told the uncle he quote, whooped his ass like a grown-ass man, end quote, according to court documents. A probable cause affidavit states Daniel provided Indiana State Police with a video of the teen in an undisclosed wooded area. In the video, the teen can be seen saying, "My father did not punch me in the eye." According to court documents, Daniel told investigators the teen was punched by an unknown individual, and that's when they decided to take him to his grandmother's house for a few days. However, they brought him back to Indiana after Wright was making decisions Kristen Muir did not agree with. On their way home from picking the teen up from his grandmother's house, Kristen and Daniel were pulled over by police, but the 14-year-old was missing from the vehicle. That was according to police. However, the mother and father's stories regarding the traffic stop were inconsistent when each was separately interviewed by police. According to the probable cause affidavit, Daniel admitted he took the teen to another location because DCS was looking for him and he wanted to protect his family. He would not tell police the location. On Friday, June 28th, Daniel and Kristen agreed to meet with Indiana State Police investigators, but later backed out. Indiana State Police searched the property in Cass County owned by Servant Leaders Foundation, a religious group based out of Tennessee. A sign saying "Welcome to Straightway Indiana Goshen" sits on that property. The parents' jury trial is scheduled for November 4th, and I'll be sure to cover that as well. So be prepared, therefore, because this one may take you for a ride. All right, next up, we got another free man walking. George Allen Kelly. Now, if you remember his case, he was accused of murdering a migrant. That ended in a mistrial. A judge has dismissed murder and assault charges against an Arizona rancher with prejudice, meaning he cannot face trial again in the future. George Allen Kelly's trial on murder and assault charges ended with a mistrial in April, after jurors were unable to reach a unanimous verdict after deliberating for more than 2 days. The mistrial would have allowed prosecutors to retry the case, but now a judge has taken that option off the table. Kelly had claimed he was protecting himself, his wife, and his home when he opened fire on a group of migrants on his property on January 30, 2023. Prosecutors accused him of ambushing the victim, Gabriel Quinn Mutiema, and said that he had a propensity of violence toward the victim's race, ethnicity, national origin, and/or immigration status. At a status hearing on April 29, prosecutors told Judge Thomas Fink they did not plan to retry the case, but wanted the charges dismissed without prejudice, which would have given them the option to bring charges in the future. At a hearing in June, prosecutors specified that they wanted to keep the chance to bring the case to a jury again if a change in circumstance made the case more viable. Those factors included the following. 1. The defendant may make statements to the media in the future or write a book which could be incriminating. 2. Unknown witnesses may come forward in the future. 3. The political situation may change, and that may change the attitudes of the jurors. And 4. The rule change that took away peremptory challenges may change would be to the state's benefit. In his ruling, Judge Fink said the reasons the state has given as to why it wants this case dismissed without prejudice are illusory. They simply are not going to happen. And even if they did, they would not address the fundamental problems of proof with the state's case. Kelly had previously rejected a plea agreement with prosecutors, which would have reduced his charges to 1 count of negligent homicide if he pled guilty. He has maintained his innocence throughout the progress. So, George Allen Kelly walks, period. They can't try him again. And with that, this case is closed. Is justice served? That depends on how you look at it. But like I just said, this one is done. This case is closed. Okay, back to this Karen Reed update. A 4th juror has confirmed a not guilty verdict in Karen Reed's mistrial. Okay. Hey, let me take you to my main man, 50 grand, the man, as he covers where this 4th juror is confirming a not guilty verdict in what is now a mistrial for defendant Karen.
Time to reveal something else you need to know tonight. Let's take a look at the big board, and more drama in Canton, Massachusetts. Up there in Norfolk County, Karen Reed. Right now, the defense is claiming that a 4th juror has come forward saying that there are 2 not guilty verdicts. Let me read it for you. A 4th deliberating juror has now confirmed that the jury reached not guilty verdicts on count 1 and count 3 once they were dismissed. Many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? No one ever asked about those counts. New papers filed by the defense. What does this mean? What is going to happen? Also, more drama in Canton. You know this case, this story has divided the town. Well, there was a little bit of chaos at the Canton town meeting last night. Rita Lombardi, who was on this program, a Karen Reed supporter, spoke at that meeting. Take a look.
The Canton Police Department and this town is facing countless and costly lawsuits as a result of their actions. We do not feel safe, and that is why. Okay, I'm not speaking for you because you're part of the selected few. I'm talking about me, common folks. I'm talking about me, the random citizen. That's who I'm talking about.
Thank you, Ms. Lombardi.
Anyone who's related to the McAlberts, you're safe, but not us.
Thank you, Ms. Lombardi.
I'm sorry.
Thank you.
Running over here. She's getting yelled at and yelling. And you stand right here.
Ms. O'Donnell. Ms. O'Donnell. You said you were going to be quiet. You were disruptive. It is time for you to leave.
And we've got a statement from the Canton police chief. I can confirm that Detective Kevin Albert was placed on administrative leave with pay as of June 13th, pending an investigation related to the testimony of Trooper Proctor in the Karen Reed trial. So let's go around the horn here. Daryl, your reaction.
W-O-W. I am stunned at what I saw that took place last night. I don't like any of it. I still don't buy the conspiracy.
Molly.
Let me tell you, even if you don't think there's a conspiracy, you have to look at this case. This case shocks me on so many levels. We have, police that are supposed to be investigating that instead are looking for nudes. We have people who want to talk more about how her face looks than what's actually going on in the trial. We have a judge that really didn't instruct the jury well enough. And the only individuals who really are going to bring some semblance of justice here are the jurors themselves, the people. The people are going to do it, and I have to believe that if I can believe anything in the system whatsoever.
Josh.
In the cradle of our democracy, This is the case America deserves in 2024. I can't look away. You blink for 24 hours, some new, absolutely out of nowhere. Lawyers have never seen this before. We are going nuts, but it's terrifying. This is what justice looks like in 2024.
Is this unfair? You have 5 seconds each.
Is it unfair?
To Karen Reed.
No, not unfair to Karen Reed. Unfair to the system.
It's unfair if she earned an acquittal and that was not on the record.
It's unfair to the citizens of the Commonwealth who deserve way better all around.
Well, Darryl Cohen, Molly Palmer, Josh Schiffer. Awesome job. Great to see you. Thank you so much.
Thanks to Vinnie Politan and the think tank. And yeah. Even I have to agree, and I have no skin. I have no skin in the Karen Reed thing. I've said that from the moment I started covering this case. It is crazy how this is going on, and one, like I said earlier. Why didn't the attorneys ask to poll the jury? 2, why didn't they gather all this evidence before they decided whether they're gonna even remotely think about trying Karen Reed for these same charges again? More drama. Now we have four jurors declaring not guilty verdicts on the top charges. How many will we get before they go back to court for another hearing? Stay tuned. All right, moving right along. We have a man who is accused of imprisoning and torturing a woman indicted for murder. Take a look at your right side of your screen. That is Mr. Timothy Haslett. He's a Missouri man accused of keeping a woman hidden in his basement while repeatedly SAing her while he was indicted on Tuesday for allegedly murdering another woman. Clay County Prosecuting Attorney Zachary Thompson said Timothy M. Haslett was charged with murder in connection with 36-year-old Jane Crossdale's death, adding that she was killed by an act of homicidal violence. He said her remains showed impact wounds consistent with a gunshot. Haslett of Excelsior Springs was indicted on 1 count of rape, 4 counts of sodomy, 2 counts of second-degree assault, and 1 count each of kidnapping and endangering the welfare of a child. He's being held in the Clay County Detention Center on a $5 million bond. Haslett's public defender, Tiffany Luty, did not immediately return an Associated Press call and email seeking comment on Tuesday. Police arrested Haslett in October 2022 after a woman told law enforcement that she had escaped from weeks of torture in his locked basement, according to a probable cause statement. She fled to her neighbor's house wearing a trash bag, a padlocked dog collar around her neck, and duct tape. The survivor said Haslett had offered her money, and she agreed to go with him to his home. Once she was in his pickup truck, the woman told law enforcement that he held a gun to her, raped her, and forced her to take narcotics. He then took her to his basement, restrained her arms and legs, and raped, whipped, tortured, and choked her every day for weeks, according to the probable cause statement. She escaped after slipping out of the chains while she believes he was taking his child to school. The woman who survived also told authorities that Haslett had described killing 2 other women he previously kidnapped, one by suffocating her with a gas mask, another who died after violent sexual torture. Oh man, before I even finish this up, this is where oh my goodness, hold on. Megan L, good to see you. Good to see you. Hold on, I mean, this is one of those stories where I'm going through this and I didn't even think about putting up a trigger warning. Yeah, because it's getting that graphic. He told her. The article goes on to say that he told her if she did not listen to him, he would suffocate her and put her in a barrel like the rest of them, according to the probable cause statement. Thompson said law enforcement officers followed more than 100 leads and spent more than 1,200 hours on the case, including searching for Crossdale and posting a missing person billboard with her photo in Kansas City. Police made progress after kayakers in June 2023 found a blue 30-gallon barrel with a skeleton inside while camping off the Missouri River in Saline County, according to police. The remains were identified as Crossdale in July of 2023, according to the Kansas Star. The charges were filed on Tuesday are based on the evidence authorities currently have, Thompson said. He said the investigation is ongoing. He urged anyone with information to come forward. He said today's indictment represents the next step in our pursuit of justice for the victims, the families and our community. The physical, psychological, and sexual torture described by the defendant's surviving victim is brutal and barbaric. And I couldn't agree more. Brutal and barbaric. I mean, that's not pulling any punches there. If you have any information regarding this case, please talk to authorities. Let them know what you know. This could be the very difference of taking this guy and putting him behind bars for good. Keep him off the street. We have a private investigator has concluded his investigation into the death of Riley Strain. That's the next story we're gonna move on with. The private investigator for the family of Riley Strain, the 22-year-old college student who drowned in the Cumberland River after a night in Nashville, released a portion of his findings this week. The 281-page report contains almost an hour of video presentation that includes important pieces of the surveillance footage from March 8th, the night Riley died. Steve Fisher was hired by the family to independently review all the evidence. He says since this is the family's report, he couldn't disclose any investigative determinations or the report's contents. But what he could share is that there was over 100 hours of surveillance video from more than 20 cameras, along with a dozen witness interviews, discussions with Metro Police, trauma surgeons, and the pathologist who performed the autopsy at the Davis County Medical Examiner's office. A lot of the information he shared lines up with what officials said in their findings, but there could be more that could be shared at a later date by the family. Fisher's investigation shows Riley was alone after getting kicked out of Luke Bryan's bar, and at no point did anyone approach him or pick him up, which dispels rumors about a possible abduction or interaction with the homeless by the river. Fisher says what the family chooses to do with the report is entirely up to them. Now, while the ending is tragic, I'm just glad that it didn't end up as a homicide, and we have to take this case further, looking for a defendant, looking for a possible suspect in what would have been, what could have been, what should have been a murder case. But like the investigators said, what the information that the family has, what they decide to do with it, it's up to them. But as far as this the investigation goes, it really is case closed. Next up, we have a U.S. Customs officer charged in the August 2019 shooting death of her husband. Well, yeah. A U.S. Customs officer is facing trial for the shooting death of her husband. Marcia Thompson is charged with the August 2019 death of Terry Thompson at their Florida home. An arrest report from Palm Beach County Sheriff's Office states an officer noted 6 bullet wounds on Terry's body and 9 fired shell casings from the living room. The couple's 2 children were home but did not witness the shooting. Marcia claimed the shooting happened after Terry threatened to slit her throat and kill her during an argument. In the arrest report, the officer wrote, "I do not believe Terry Thompson posed such a threat that deadly force was necessary." In court documents, Marcia's defense claims she acted in self-defense, and she was suffering from both battered spouse syndrome and post-traumatic stress. A judge previously denied her motion to dismiss charges under Florida's Stand Your Ground law. Opening statements expected on this past Friday. Just yesterday, she's charged with first-degree murder. Let's get the breakdown from Court TV.
All right, we head to Florida now, where Court TV is getting ready for the abused wife or murderer trial. Marcia Thompson is charged with first-degree murder in the shooting death of her husband, Terry, back in August of 2019. Now, she claims she was in fear for her life and that she suffered years of abuse at his hand. Well, today, Thompson was in court for a hearing on several motions, including a state motion to keep out allegations of infidelity by the defendant's husband.
It's our position, Judge, that the alleged infidelity is part of the abuse. The infidelity is not just infidelity, it's something that he tormented the defendant with and taunted her with. It's something that he abused her with, that he put her in a position where she had no choice and was forced to live in that condition. She knew about it. He told her about it. She also knew when he had STDs, and she knew when he brought them home, and she was forced to have unprotected sex with him and contract those STDs herself.
The state says the alleged infidelity is not relevant and should only be introduced when discussing Thompson's character.
We'll get to decide whether Marcia Thompson is an abused wife or is she a cold-blooded murderer. When Court TV begins coverage of this case, I'll be sure to keep track of that as well. Next up, the body of 17-year-old missing teen Tiffany Bostic is found, and there's an arrest. This is what was trending in true crime. So I'm gonna go ahead and take you to my good friend Julie Grant, so she can.
Now, for For what's trending in true crime, a missing 17-year-old girl is dead, and now a 17-year-old boy is charged with her murder. Rising high school senior Trinity Bostic went missing on June 29th in Macon County, Tennessee. Her remains were found on July 3rd in Hendersonville, which is about 45 miles away from her home. About a week later, police arrested and charged the 17-year-old suspect with first-degree murder, but they haven't released his name. So Trinity's family initially reported her as a runaway to police. And now her friends, some of them are wondering if that designation might have affected the search.
I feel like it just wasn't taken very serious. And I feel like if it had maybe just been taken a little more, she may not be gone.
So we're wondering this morning, did calling her a runaway perhaps slow down justice? Let's bring in our power panel now. With me, entertainment reporter Kinsey Schofield, criminal defense attorney and former prosecutor Franz Borchardt, and criminal defense attorney and professor Don Malarsic. Great to have you all on the show. Kinsey Schofield, I'd love to begin with you, please. Your thoughts on the designation and whether it affected things.
I mean, I think even when someone is classified as a runaway, they should receive an urgent response from law enforcement today. In Tennessee specifically, the Department of Children's Services created the Human Trafficking Response Team and saw more than 500 cases come through the unit just in 2023. And the majority of those cases were youth-centered to be, or were youth that were considered to be dangerous runaways. The odds of a runaway finding themselves in a vulnerable position are extremely high, and my prayers are with Trinity's family. This is a horrible story, and it does feel like something could have been done earlier.
Right. This is a tough one. So many unanswered questions this morning. Franz, to you next, please. Your thoughts on the designation.
So I don't know that I'm willing to blame law enforcement if they relied on information provided by the victim's family. If they called it in as a runaway situation, why would law enforcement think anything different? I'm also unsure that her classification as a runaway would have really changed anything. Look, I get it, Julie. I'm sorry that she is dead, and I know that her friends who loved and cared for her are trying to wrap their brains around this unnecessary death. I just don't know if pointing fingers at either the family or law enforcement really improves the situation. And again, I'm not ready to blame law enforcement for relying on the family's classification of her being a runaway.
Appreciate those points. Franz, thank you. Last but certainly not least, Don Malarsic, your take here.
You know, Julie, for friends and family members of a victim like this, it's excruciating, right? Every day, every hour, every second that a loved one is missing increases anxiety, increases hopelessness. So I think Trinity's friends are asking very good questions, and we should ask those questions. You know, what impact does classification have on the search for a missing individual? Is race a factor in some circumstance? But I tend to agree with Franz. I think in this situation, there are not infinite resources, and police have finite resources. So I think they did the best they could with what they knew, and looking for a teenager who may have run away, I think is different, quite frankly, than a 12-year-old who might have been abducted. So I think those two situations are different. I think Franz makes a good point. The police went on the information that they knew. That doesn't mean we don't look for them, and they certainly are vulnerable, but these resources are limited.
So true, Don. Thank you for that. Our hearts go out to Trinity Bostic's family. I know I speak for all of us when I say that. We'll continue providing more details as they're released.
And I'll keep up with this case as well. So whenever the crew at Court TV gets information, I'll be sure to bring it here to you. But in the meantime, like them, I send my deepest condolences to the family and friends of Trinity Bostic. Next up, another case that may be worthy of a trigger warning. So let me go ahead and cover my base now. Alright. Now that we got that. Okay. An Ohio mother and son charged in a heartbreaking and horrific case of child abuse were in court on this past Wednesday. In June, couple Matthew and Charles Edmondson were indicted on multiple charges of child abuse on accusations they tortured their 5 adopted children. 2 weeks later, authorities announced charges against Matthew's 20-year-old son, Bailey Edmondson. Matthew and Charles were indicted on 26 more charges. On this past Wednesday, prosecutors in Matthew's hearing urged Judge Richard Ferenc to increase her bond from $500,000 for her initial indictment, with the addition of increased charges that could carry a prison sentence of 208 years if convicted on all counts. The prosecutor described the conditions the adopted children were held in, saying withholding food to the point of starvation, withholding water, clothing, being forced to stay in basically a dungeon room in the basement in diapers. Another member of the prosecutor's office said they have evidence Bailey was complicit and actively involved in some of the children's discipline. A judge ordered Bailey held on a $500,000 bond. Matthew's bond was raised to $1 million. The Clermont County Sheriff's Office said the investigation began when an adult adopted son accused Charles of sexual assault in 2022. Court documents reviewed by Scripps News Cincinnati showed Charles told a court investigator about the accusation of abuse in a report submitted to the court December 5, 2022. The investigator said the son is one of the most vulnerable people I have met due to mental illness. On December 14, 2022, a judge granted Charles guardianship over the child. Charles was indicted in October 2023 and eventually sentenced to 3 years in prison. ProKids Executive Director Tracy Cook said people often overlook the basic signs of abuse in other children that could lead them to getting help. There are things we can do to help these children, Cook said. Cook said withdrawal, aggravation, odd comments, extreme fear, and unexplained injuries can be common signs of abuse within a household, and she urged anyone with a reasonable suspicion to call their local county jobs and family services department if there's any doubt a child may be abused. People often hold back and don't report because, oh, I'm not sure. You don't have to be sure, Cook said. Let me tell you guys, there is no good reason for parents, natural, foster, or adopted, to abuse children. None. Personally, I look for justice. This is the kind of case I would definitely seek justice for all those kids that were involved. When I say involved, I mean the ones that was on the business brunt end of the abuse. And as for Matthew and Bailey Edmondson, I hope to God they get exactly what's coming to them. The raising bond is only the beginning. Next, we're about to reach the start of the what is being billed as the Black Swan Murder Trial. Florida's real busy this time of year. That's why this is one reason why I declare this a summer of justice. But let's go back to Vinnie Politan for a breakdown of the Black Swan Murder Trial that will begin July 22nd.
Time to reveal something else you need to know tonight. Let's take a look at the big screen. There she is. This is Ashley Benefield, accused of murder. She is a swimsuit model, former ballerina, the defendant in the Black Swan murder trial. And look what's happening, folks. We've got a trial date coming up. This is like scheduled right after the Baldwin trial, or right towards the end. This trial will begin July 22nd down in the state of Florida. If you don't know about this case, take a look.
Everything was very normal. I had 2 loving parents.
That is 21-year-old Eva Benefield, reminiscing on what life was like with her parents, Doug and Renee. Eva lost her mother back in December of 2015 from an undiagnosed heart condition. From then on, her family life became unsettled. 9 months after her mother's death, Eva's father, Doug, met 24-year-old Ashley Byers, a ballerina and swimsuit model, and 2 weeks later, they were married.
He eventually fessed up and he said, yeah, so we're dating. The next day I met her and we picked her up from the hotel that she was staying at here in Charleston. And then the following day, it was a Sunday, he told me that they were actually married, not just dating.
Their marriage quickly began to deteriorate once Ashley became pregnant.
Shortly after that is when she starts all the drama of accusations, but that started the real problems between Ashley and Doug.
As Ashley and Doug's relationship became more and more strained, the two became embroiled in a bitter custody battle over their young daughter. They went to court to hash it all out, but Ashley went on to make a shocking accusation, claiming that Doug poisoned her while she was pregnant.
It was a dramatic accusation that involved days of testimony in court in Manatee County. We had nationally recognized experts that testified, and there was just no evidence at all.
It was an accusation the judge didn't believe, saying Ashley's story didn't possess a scintilla of truth. Despite the bitter conflict, Doug had been trying to work things out with Ashley, but the tensions between them grew. And on September 27th, 2020, it all came to a head.
She's with me now, quite upset. The weapon is here. We need the police before her mother and the little girl gets back from the park. I don't want them to find it.
Yeah.
You want me to go over and look at anything, or just wait for the police?
No, I want you to just wait for the police, okay? So they were in an argument?
I don't know. She came in. She was quite hysterical. I didn't know who was banging on my door. Said that he attacked her and she shot him. They've been having trouble.
Ashley shot Doug with a .45 caliber handgun, an act that took the life of Eva's only surviving parent.
I mean, at first, it was really devastating, but I have a great support system. I have a lot of good friends and family.
Ashley claims she acted in self-defense, but prosecutors aren't buying it and have charged her with second-degree murder.
July 22nd, it all begins. And by the way, she's out on bond, so she'll be walking in and out of the courtroom. She's been free ever since these charges were leveled against her. She's raising their child. She's living with her mother down there in the west coast of Florida. So this is a big case. The Black Swan murder trial begins July 22nd right here on your front row seat to justice.
And to no one's surprise, this case is going to be covered by your drama-free true crime destination. So be ready for that. We have an update on Courtney Clenney and her parents in the computer hacking case. Prosecutors have dropped computer crimes charges against OnlyFans model Courtney Clenney and her parents 2 weeks after a judge ruled key evidence was admissible in the case. Courtney is charged with second-degree murder of her boyfriend, Christian Obumseli, who was stabbed to death in the couple's Miami apartment in 2022. In a separate case, she and her parents, Kim and Deborah Clenney, were accused of trying to access Obumseli's laptop illegally after his death. Let's go right now to breaking.
We've got some big breaking news just coming in. Want to share with you now the OnlyFans model murder case for Courtney Clenney just had a big change as the computer crimes charges have now been dropped. Those charges are no longer part of this case. Clenney, along with her parents, Kim and Deborah Clenney, were all being accused of illegally accessing a laptop that the prosecution had said belonged to Courtney Clenney's boyfriend, Christian Obumseli. But Clenney's defense team had contended that that was a shared laptop, that it belonged to her too, and they both would use it. And this was quite a fight. You've seen Courtney's attorneys come on this program and talk with us about this, and they got a big ruling from the court recently that we spotlighted, and now the prosecution has had to withdraw these charges as there's no substance for them any longer. So now here's what this means. It means that the computer crimes case is gone. It goes bye-bye. Courtney Clenney's no longer facing that charge, and her parents are no longer facing any charges either. The only charge Courtney Clenney is facing is the homicide charge. She's accused of stabbing Christian Obumseli to death in their Miami apartment back in 2022. Now, she claims the stabbing was in self-defense. The state claims that it was a cold-blooded murder. So this is where things lie with this case. Only the stabbing is going to be an issue now. There is no computer crimes case any longer, just the stabbing case. And we know that that's going to be quite a battle, as her defense team has come on and said that she was a victim of abuse. So we will see what the jury finds. We know that the relationship was very toxic. And there was some very upsetting video evidence, pieces that we've shown you on Court TV, and still no trial date for that one. So for her trial on the homicide charge, we don't have any date. We'll keep you posted on that. But for now, the case has just changed. Big win for the defense. Her parents are free from any potential criminal liability now, and we'll see where things go with the case over the death of Christian Obumseli.
Thanks to Julie Grant for that update. Now we'll be hearing from her in a little bit. But as far as that case goes, I'm waiting to see how this goes as far as the homicide case. Now that the computer hacking charges have been dismissed, I'm waiting to see which way is this going to go. Is Courtney Clenney going to get off from is going to be acquitted from these murder charges, or will she be convicted and have to do time behind bars? Another wait and see, and I'll be looking to cover this as well. All right. My next two articles, I put the words "justice served" in it, but here's the difference. This first one, I have to put a question mark behind. All right. Take a look at the right side of your screen real quick. This young woman who stabbed a teenager to death during a fight was sentenced to only 3 years in jail, the maximum allowed under a plea agreement she reached with the prosecution. 20-year-old Brianna Barazzini pleaded guilty to involuntary manslaughter after she was initially charged with the murder of Halia Culbertson, age 17, who was stabbed to death on March 26, 2023. Prosecutors conceded that Culbertson had been the antagonizer in the incident that led to her death, saying that she had challenged Barazzini to a fistfight after the two ran into each other in a smoke shop. When asked to leave the store, Culbertson waited for Barazzini outside. When Barazzini exited, Culbertson continued to push for a fistfight and slapped Barazzini in the face. Surveillance video shown in court showed Barazzini step back after she was hit before wielding a knife and attacking. Barazzini's attorneys said during sentencing that she didn't want to engage at all. She was afraid. Culbertson's mother addressed the court with an emotional victim impact statement, telling the judge that Barazzini's actions amounted to a heartbreaking betrayal of a young life taken by someone who was once a best friend. My daughter was not killed by a faceless stranger, but by a person who was once trusted and loved, a friend who knew her, understood her, shared countless moments of her life. This betrayal makes the loss even more profound. It was not a random act of violence, but a calculated decision made by someone who was supposed to protect and cherish her. Prosecutors said told the judge that Barazzini was motivated by rage and urged him to sentence her to the maximum available sentence. Had Barazzini had been convicted of murder charges, she would have faced a sentence of life in prison. The maximum sentence for the reduced charge of involuntary manslaughter was 3 years. Addressing the court before she was sentenced, Barazzini said, "Not a day goes by this incident hasn't been on my mind. I can understand and appreciate the harm I have caused now. I will be living with this guilt for the rest of my life." The 3-year sentence wasn't enough for Culbertson's mother, who told the judge, This is not just a matter of justice for a victim. It is recognizing the deep personal breach of trust, the devastating impact such a loss has on a family. My daughter's death is a stark reminder of how trust can be shattered in the most unexpected ways, and it's vital for the court to consider this profound betrayal as part of the pursuit of justice for her. Let's go inside the courtroom right now. So we can see this this sentencing, and you decide for yourself. In fact, I'm gonna go ahead and set that up as a poll right now. Let me see. Start a poll. Let's see, Brianna. Let me get the last name spelled correctly here. Okay. Sentenced to a maximum of 3 years by plea agreement. Is justice served in There you go. Now that I have a poll up, here's the sentencing.
I never once thought I would be here today with these charges. I also have never been one to start a fight. I'm always a person to back away from confrontation. Not a day goes by that this incident hasn't been on my mind. I understand and feel for the victim's family, as I know the harm I have caused them is indescribable. I also feel for my own family, as the situation has caused them a lot of pain. I can understand and appreciate the harm that I have caused now. I would be living with this guilt the rest of my life. I took a life, and I understand the victim's family will suffer for the rest of their lives, as will my family for what I've put them through. I pray and will continue to pray for all parties involved.
All right, thank you. This is a tragedy. Two young women, both acting somewhat immaturely. In my day, you had a fist fight, you had a fist fight. You either won or you lost. Now everybody wants to bring a weapon. There are mitigating factors here. She is eligible for probation. Now, I'm not going to give her probation, but she's eligible for probation. Your family's going to get to see you, spend time with you, watch you grow up, see your wedding. They'll never get that opportunity. I do believe that the case was, I don't control plea bargains, but I think it was an appropriate plea bargain. I was fully ready to go to trial. We started a trial. I don't make the decisions about plea bargains, but I think it was an appropriate one, having watched and reviewed all this. So the court's considered the factors in sentencing in 29, 11, and 12, and gone through the more serious factors, less serious factors. You have no record whatsoever. You have a lot of people who think a lot of you, and you obviously have a lot of good things in your life. So did she. That's what makes this a tragedy. I'm going to give you a 3-year prison sentence, 3 days jail credit. You are going to have the ability for early release, and I will consider that at the appropriate time. They'll have the right to come to court and dispute that. You will go to prison. If you have a bad prison record, you're not getting out early. So you need to avoid conflict in prison and/or any serious school violations. Once if you get out of prison early, you'll be under the court's supervision and probation, my supervision. If you don't get out early, you'll serve your sentence, and when you do get out, you will be supervised for a period of 1 to 3 years. It's called post-release control. Post-release, you're out of prison. Control of prison authorities will assign you a parole officer and monitor your behavior. If you would violate, you could go back for another 1.5 years. So if everything went wrong for you, you could do 4.5 years. If you do well in prison, take programming, you get accept responsibility here. You have the chance to get out early. They're going to take you into custody now. You may have to sign that form, please, prison imposed.
Yeah, would you waive the fine and court costs?
Fines and court costs are waived.
Thank you.
The weapon will be confiscated and destroyed. I do want to thank everybody. I think everybody obeyed the rules of the court in a tough situation.
There it is. Brianna Barazzini sentenced to 3 years on a plea agreement. But the question still remains, was justice served? If there's no response here in the YouTube chat, I'll set that post up again. I'll set that poll up again on my community page. I'd love to hear from you and what you think. So, from justice served with a question mark to justice served with an exclamation point. A judge sentenced the South African native convicted of killing 2 women in Alaska to 226 years in prison. In case you thought that's a mistype or misspeak on my part, all right, I'll read that again. A judge sentenced a South African native convicted of killing 2 women in Alaska to 226 years in prison. In February, a jury found Brian Stephen Smith, age 53, guilty of more than a dozen charges in the murders of 52-year-old Veronica Abuchuk and 30-year-old Kathleen Jo Henry. Both women were from small villages in western Alaska and had experienced homelessness. I'm going to go ahead and send this one over to the Honorable Judge Ashley Wilcott for Court TV, and we are going to hear this sentencing in its entirety.
Turning our attention now to Alaska, where day 1 of a sentencing hearing is underway for convicted killer Brian Smith. A jury found him guilty earlier this year of more than a dozen charges for the murders of 2 Native Alaskan women. Both 30-year-old Kathleen Jo Henry and 52-year-old Veronica Abuchuk were found beaten and strangled to death back in September of 2019. Now, while being interrogated, Smith made a confession and later told this to investigative reporter David Scott.
First of all, that was a false confession I did there. That story was false. The police told me that they would not tolerate me giving the real story. And right at the beginning, the police also made it clear that they wanted to hear about sex. They asked me, what did I do with the woman that was my alibi?
That's what it was.
The so-called short-haired woman. Yeah.
She's never been identified or surfaced, right? I mean,
who said she wasn't identified?
Well, she's not in the record. Your defense attorney didn't produce her as a witness.
Yeah, no, we didn't bring her in. She got me confused with another man, somebody that had attempted to sexually assault her at one stage, and she got me confused with this guy.
Yeah. It sounds, Brian, like not much of an alibi.
My mind was buggered. My mind was buggered when that interrogation started. I knew I was weak. I knew I wouldn't.
They're offering you something to drink. They're offering you something to eat. You don't look like you're being tormented. You prolonged it. You asked them, you guys have to go home now? I got more to say.
That's because they asked me a question, I give them an answer, they're not happy with it. So I give it another answer. I try different ways of explaining it to them.
Then so I have 5 pages of quotes from your own lips, Brian, right? Full of admissions and confessions and acknowledgments and appreciation for the police and self-awareness that you've gone too far and now you're in deep shit.
Police said that they want to hear the sex side of things. So I gave them all the sex they wanted. That is non-confrontational de-escalation.
That sounds like a guilty man who's coming clean.
Well, then I did it well. Then I succeeded.
You did it too well?
I succeeded in de-escalating and acting non-confrontational. Right. I succeeded in that.
Why would you add details like defiling her corpse?
Once again, the police wanted that. It smells.
Are you somebody who's incapable of telling the truth, Brian?
The problem is, when I speak the truth, people don't believe me.
And I speak the truth, people don't believe me. Well, before the proceedings got underway earlier, the judge told the court they would be using the victims' names as a way to restore their personhood. Let's listen to that together.
The essence of what happened to the 2 women that we're here about today is that they're, among other things, they were treated as something other than human. And they were dehumanized. And their names are out there anyway. Their names are in the public record and are being discussed by a lot of people in different places. It seems to me that the more respectful thing to do is to refer to them by name as we go through this process, rather than something less than a full name. And that will help actually, to some tiny extent, restore their personhood.
Again, the jury found him guilty on 14 charges for these 2 murders. We want to take you now inside the courtroom for today's sentencing hearing for Brian Smith. First up, the court heard from the daughter of one of the victims. Let's go in.
It was an insignificant moment that became significant to me. I feel her all around me, watching over me. No one can take that away. This experience has taught me so much and has showed me true love never dies. There are family who cannot be here today, but wish they could, including my father, her grandkids, her daughter, her son, aunts, and uncles of mine. We all wish she had it so much better. It's a relief knowing the defendant will rot in prison. I hope he is swarmed with guilt someday, knowing he stole so many people's joy. I wish nothing more than the defendant lives the rest of his life without joy, and I'll dance the day he dies. To me, he will always be an unintelligent, sick human being who couldn't comprehend the meaning of life. John Prine said it best, some humans ain't human, some people ain't kind. Forget the defendant's name and remember Veronica Rosaline Adalchuk and Kathleen Joe Henry. On behalf of my family and myself, I want to give a sincere thank you to Detective Brendan Lee, retired Detective Jeffrey Bell, Bristol Bay Chief of Police Jeff Elby, Detective Dave Corby, Detective Christy Mercer, Detective Christina Roberts, Captain Bianca Cross, Sergeant Jake Baker, Computer Forensic Brandon Hunter, FBI Special Agent Cellular Analysis Survey Team, District Attorneys Heather Norbrega and Brittany Dunlap, as well as their assistant John Bolton, the APD Crime Scene Unit, APD Parole, and Alaska State Crime Lab. Everyone at Alaska's Victims for Justice, but specifically Golda Ingram, Felicia Christian, and retired advocate Michelle Evans. Kathy Hansen from the Office of Victim Rights, as well as everybody who works there. Thank you all so very much.
Is there someone else to speak?
All right, we do need to take a break. I want to bring you a little bit of the color of the courtroom that is offered from our team that is following this, and that is that there are women in this packed gallery with a red handprint across their mouths. This is a symbol of the missing and murdered Indigenous women movement. We do need to take a break. When we come back, we're going to hear from the state of Alaska. Let's hear what they have to say up next. Welcome back to Court TV Live. I'm Ashley Wilcott. So appreciative of your joining us today. Let's turn now back to Alaska, where we are watching the sentencing hearing for Brian Smith. He was found guilty earlier this year of more than 24 charges in the murders of 2 Native Alaskan women. Let's go back in now. We heard from a victim. Now we are hearing an argument by the state. Let's get back in.
Your Honor, the defendant, Brian Smith, engaged in purposeful and predatory pattern of conduct. He targeted some of the most vulnerable women in our community. He tortured and degraded and then discarded Kathleen Joe Henry and Veronica Adalchuk for his own sadistic pleasure. The last moments of Kathleen Joe Henry's life were filled with fear, and horror and helplessness that no human should have to endure, and he recorded it in narcissistic and flagrant fashion. Prior to killing these women, the defendant had bragged to his now deceased girlfriend, Alicia Youngblood, about murdering others. In his interview, he called that fantasy and boasting, but it is evidence of his mindset and his potential for rehabilitation or lack of potential for rehabilitation. As you're aware, the defendant had on his phone images of a woman whose identity has not yet been 100% confirmed. I attached those images to the sentencing memorandum because they were discussed in the interview but not shown to the jury, so Your Honor had not seen them. They show a woman who is helpless in the grass, in a fetal position, covered in blood. When confronted with these images at the airport, he described a sexual encounter after the death of Kathleen Jo Henry, where he left her passed out on the grass. He said he took those images to boast. Those images appeared to be more than passed out. Certainly, she was harmed. But those images show a complete lack of remorse for what he did to Kathleen Jo Henry and a continuation of the predatory pattern that we know he began with Ms. Avowchuk. When you're sentencing Mr. Smith today, you have a wide range that you have discussed of sentences that you can employ for each charge. And under the law, the state is asking you to find him a worst offender and sentence him near the at the high end of the range for the homicides, but near the high end of the range for the sexual assaults. When you look at the composite sentence, you have to find that he is a worst offender and that the confinement for the length of time that the state's asking is necessary to protect the public. I think under the facts of this case and Mr. Smith's behavior, that finding is really easy to make. A case like this does not come around often for good reason. There are very few, as long as I've been doing this work, I still believe that most people are good, and there are very, very few truly evil humans in the world. Mr. Smith is one of them. He is a person that should never be permitted to walk among us. He should spend the rest of his life in jail, and your sentence should make a statement that the women's lives that he stole so brutally mattered. And that's why the state is asking for a mandatory 99-year sentence for the death of Kathleen Jo Henry. That sentence is warranted based on the substantial torture aggravator that was found by the jury. It's mandatory 99. But her life isn't worth more or less than Veronica Avowchuk's. What he did to her was equally cruel. He took her in off the street. She was impaired. He violated her. He photographed or filmed at least parts of it, likely all of it. I know it's deleted, but we have evidence that he filmed parts of it. He discarded her and he boasted about it. Her life is worth no more or less than Kathleen Jo Henry's. The maximum 99-year sentence for that is warranted. The state has laid out other appropriate sentences within the range for the tampering with evidence charges and the sexual assault and the second-degree charges. And when you look at the Cheney criteria and the things that you have to consider in sentencing, community condemnation, your community is here, Judge. His community is here, and the community condemns these actions. Isolation, he needs to be isolated to the maximum extent and for the longest amount of time possible. And potential for rehabilitation, somebody who brags and boasts about what he has done, who films and degrades the women while he is doing it, shows absolutely no potential for rehabilitation. There is true evil in this world, and it's sitting in this courtroom with us. Judge, and I ask that you sentence him to a composite active term of 226 years for these crimes. Thank you.
one of the arguments that I laid out in my sentencing memorandum and one of the points of law that comes up in our case law is, I think, especially relevant now given the nature of the state's argument, which is the court does have to consider the Cheney criteria. The court does have to impose essentially the lowest sentence possible that would achieve those Cheney criteria. One of those Cheney criteria is community condemnation, but what the state just asked the court to do was to sentence retributively. And the court is not allowed to do that. And the case law is very clear on that. It's referred to as a prohibited way to sentence somebody. What the state asked was essentially pay a life for a life, never let him back out because he's evil, and that is retribution. That's not community condemnation. That's not an appropriate sentencing goal. That is improper. What the court does have to consider is what sentence would achieve the Cheney criteria, which again, like I said, does include community condemnation, does include the extent to which somebody needs to be isolated. And what the state asked for was the longest amount of time possible for him to be isolated. The longest amount of time possible for Mr. Smith to be isolated is the rest of his life. Mr. Smith is already going to be incarcerated at this point for the rest of his life because he's getting a mandatory 99 years on count one. So that's been achieved. You can give him 99 years, you can give him 198 years, you can give him 400 years, and the length of time he's incarcerated is going to be exactly the same. And that's the point that I think we need to discuss about sentencing within the Cheney criteria and sentencing retributively, which is what the state is asking you to do. It would be easy to play into that and to say, well, you know, there's an emotional need for people to hear a big number. There's an emotional need to have a big number on the front page of the paper tomorrow. You know, people have been following this in the media. People have been following it very closely. There's a lot of emotion about it. There's been protests since the verdict, and people want to see a big number. But again, that's not what the court is here to do. I think Your Honor has done an appropriate job of listening to that, hearing it, taking it in. But there's a reason that sentencing is entrusted to the court and not the public or the press. Because the court is able to understand and follow the appropriate sentencing criteria and issue a sentence using that criteria. And I say that because, as I said in my brief, there's no functional difference between 100 years, 200 years, or 300 years. So in this case, based on the court's obligation under the law, we believe that the court has to impose a sentence of, again, I think, barring appeal, obviously, the mandatory 99 on count one. Beyond that, for count 9, murder in the first degree, 30 years, 50 years, 99 years is not going to matter. At least 30 of it has to be consecutive, so 30 is the appropriate number there. And while the state said that it wants to send a message that the lives are equal, and I've said this in a few murder sentencings now, I hesitate to ask the court to sentence based on the value of a life because that gets into relatively inappropriate consideration down the road. Because asking the court to say we're going to sentence somebody based on what the lost life is worth, which asks us to measure the worth of human beings in a, I believe, inappropriate way. And what the court has to do is consider the composite sentence here and what it is imposing in full. So even with the mandatory time, the mandatory consecutive time, I believe my read of it is you're looking at 132 years with 3 suspended is the lowest possible sentence that the court can impose under the law because of the mandatory suspended time and the mandatory consecutive time. And there is no difference between that sentence and a 200-year sentence. And because of that, we believe the court has to impose the lower end of that at 132 years and 2 days with the 3 suspended because it will achieve everything a longer sentence would achieve without leaving anything out. So as I said in the brief, that's what we're asking Your Honor to impose. As for the mandatory probation, we're not taking a position on the probation conditions. Based on the reality of the sentence, they're not going to matter, so we're not objecting to any of them. So, as we said in our brief, what we're asking the court to impose is 132 years and 2 days with pre-suspended 10 years of probation on the conditions laid out in the PSR.
No, thank you.
It's time for both sides to keep making whatever points they think it's important for me to consider. So, okay.
I don't have anything else, Judge.
Stay with us for more in this Alaska courtroom. The judge speaks next. He's already said we are using these victims' names to restore their personhood. Stay tuned. We'll bring you more.
Tonight, on closing arguments, high drama in the Alec Baldwin Manslaughter Trial. We'll unpack today's biggest moments as our experts weigh in.
Closing arguments with Vinnie Politan. Tonight at 8/7 Central, only on Court TV.
Who is Billy Ray Turner? How does he have any connection to Lorenzen Wright?
He was manipulated.
See plans, he plotted. See the reason why he's gone. Accomplice to Murder with Vinnie Politan. Sunday night, 8/7 Central, only on Court TV.
Now.
We are bringing you the sentencing hearing for convicted killer Brian Smith. He's facing 99 years in prison after a jury found him guilty of murdering 2 Native Alaskan women. Let's get you back into court. The judge has started speaking. Let's go in.
The mandatory 99 on count 1.
And I think
Beyond that, for count 9, murder in the first degree, 30 years, 50 years, 99 years is not going to matter. At least 30 of it has to be consecutive, so 30 is the appropriate number there. And while the state said that it wants to send a message that the lives are equal, and I've said this in a few murder sentencings now, I hesitate to ask the court to sentence based on the value of a life, because that gets into relatively inappropriate consideration down the road, because it's asking the court to say we're going to sentence somebody based on what the lost life is worth, which asks us to measure.
All right, actually, we're going to come out and go back in just a moment to hear what the judge had to say. But just a reminder, more than half a dozen, let me start again, more than a dozen charges, 14 charges. That's how many charges Brian Smith was convicted of by a jury. And remember, this is the murder of 2 Alaskan Native women. There are individuals that are in the courtroom with a red handprint over their mouth supporting the murder of Indigenous women. Let's go back in to hear from the judge.
So, if you haven't heard this and you have a tender heart, you may not want to listen to this part. First, as I noted, the jury did find that count 1 involved substantial physical torture. That finding, along with the facts that I had viewed in the videos and that were established at trial and that have been provided to me in documents like the police report, the police interview transcript, leads me to the conclusion that count 1 is a worst in category or among the most serious murders in the first degree. But I need to go through and enumerate some of the evidence that leads to that conclusion. Evidence in those videos is relevant not just to this seriousness of the offense criterion, but it's relevant to several of the other issues I have to consider. So the first video clip, there were 12 videos. And the first video clip didn't involve any speaking. It involved strangulation. Ms. Henry can be seen from the waist up. She's been badly beaten by the point this first video clip occurs. She has a swollen black second video clip, there's more strangling. And the number, there is some narration or discussion by Mr. Smith. One of the things he says is, quote, unintelligible. In this video, he also he punches her in the camera. Third video clip, among other things, he says, quote, and you're alive and you die. And you're alive and you die. So I guess I need to stop this because the blood is getting to the floor. As he's saying you're alive and you die, his hands are being alternately lifted and pressed against the back. His hands are alternately being lifted and pressed against your neck. In the fourth video clip, he acts upset because she wasn't dead yet. He's kneeling on her chest to make it harder for her to breathe. Among other things. In the fifth video clip, there's still strangulation going on. Quote, are you still alive? It's been like, what, 20 minutes? It's time to finish this fucking job, bitch. Unquote. In the sixth video clip, quote, for my fans out there, hit the like. People need to cooperate. In the seventh video clip, there's no speaking, just more strangulation. In the eighth video clip, he ties a cord around her throat, sits on her chest, fondles her breasts, while he's humming an AC/DC tune. Tightens the cord. She's very weak. He uses her own hand to slap her. Quote, up bitch, you are taking so long, you have to be taught how to die these days. Unquote. In the 10th video clip, among other things, he kicks her in her vagina, stamps on her chest, stomps on her chest, again goes through the you live, you die, you live, you die, you live, you die game that he's been playing. He says, sadly, in my movies, everyone dies. I get the Oscar, bitch, only me. Please finish, I'm tired. In the 11th and 12th video clips, there's more strangulation, sitting on the chest, slapping with her own hand. She's obviously very weak and dying. At the end, he complains that his hands aren't as strong as they used to be. In addition to those statements, which are related because they're relevant to some things I'm going to discuss in a minute, he talked in his police interview about having violent sexual fantasies with his young blood, his girlfriend. And there's a lot of discussion about that, a lot of discussion about how he showed her some of the photos that he'd taken that were real in an effort to make the fantasies that he was discussing with his young blood more real.
We are approaching the top of the hour. We have to take a break. The judge ultimately sentenced Smith to 226 years total, just as the state requested. That includes 2 99-year sentences for the first-degree murders of Kathleen Jo Henry and Veronica Abachar.
$226 years for 2 murders. Yes, it's safe to say that not only will he end up rotting in prison, no chance of getting out, but notice what the defense attorney asked the judge to pass sentence based on the value of life. Ladies and gentlemen, one of my favorite sayings is be careful what you wish for. You just might get it. And I added this little part to it. Be careful what you wish for, you just might get it, but you might not like the package it comes in. In this case, the defense attorney asked the judge to sentence Brian Stephen Smith based on the value of life. The judge must have deemed that since every life is precious, and he took 2 from this earth, regardless of their situation and circumstances, he ends up now doing what will be the rest of his life in prison. Well, like I said at the beginning, the first case I gave you was justice served with a question mark. This one is justice served with an exclamation point. Moving onward. Scott Peterson. The word is now is that Scott Peterson's case is literally hanging on by duct tape. Yeah, that's right. Literally being held together by duct tape. They say duct tape can fix anything. It might fix Scott Peterson's biggest problem, incarceration. Peterson was in court Thursday for the 7th time this year in his ongoing bid for a new trial. He's currently serving life without parole for the 2002 murders of his pregnant wife Lacey and the couple's unborn son. Thursday's arguments focused on duct tape. Excuse me. Namely, a piece of duct tape that was on Lacey's pants when her body washed ashore along the San Francisco Bay in April 2003. Peterson appeared at the hearing via Zoom from Mule Creek State Prison, where he is currently being housed, as the state and defense battled over what lab will test the duct tape and who will foot the bill. We're going to go to Court TV right now for more on this story.
Welcome back to Court TV Live. I'm Julie Grant. And during this hour, we're bringing you the very best moments from Thursday's hearing for convicted killer Scott Peterson. With the help of the Los Angeles Innocence Project. That is not the nationally known Innocence Project. That is a small local group not affiliated with Barry Scheck's group. Peterson and his defense team are now pushing forward, trying to get him a new trial. Now, in this next portion you're about to see, the defense presents its issues with the handling of some DNA testing and calls into question the chain of custody of the case evidence. Let's take a look.
The chain of custody are an abomination. I've never seen such poorly documented evidence. Collection, retention, transfers. This is far, far short of what we need in terms of a documented chain of custody. We still don't have an answer to whether the 3 swabs exist. We still don't have an answer to whether there are 3 slides or 1 slide. As we indicated in our statement, the handwritten note, which the DOJ, the lab that they want to use, contends is a chain of custody record, is very legible, and it says there's 1 slide, not 3 slides. We didn't really realize that there was this derivative evidence out there that could potentially be very material, and it could be exculpatory, until we saw what they're contending are chain of custody records. We know, for example, if this is what they're saying is the MPD chain of custody for, it says white box. It doesn't say what's in the white box. We also know it has a scanned barcode. What normally happens when you have a chain of custody, we have property and evidence logs. You get a printout of every single item of evidence that was collected, where it was taken, when it was entered into property and evidence, when it was checked out, by whom, where it went when it was checked out, whether it was to the lab or somewhere else, when it was received by the lab, what was done to it was while it was at the lab, and when it was returned to police custody. We need chain of custody, we need current property and evidence logs from the scanned barcodes for all of the evidence in this case. There was evidence that Mr. Peterson provided, blood sample, saliva sample.
Hang on. Number 1, court report.
Sorry.
Number 2, in the context of the 1405 motion, now the 1054.9 motion that we're going on Monday.
Yes, correct.
The court's order was limited to the chain of custody and the items and the logs for the items that the court had ordered be tested.
So I'm merely suggesting that this is one reason why a complete chain of custody is needed.
Which is going to be taken up under the 1054.9 motion that you got.
But I'm talking about specifically for the duct tape and for any derivative evidence, including the slides, including the swabs, including the adhesive, which this is a capital case that prosecution wanted to execute my claim. But these records are, as I said, an abomination. This is not a complete record of the chain of custody for this item of evidence that we are seeking to have tested. We would like to have complete, current, barcode scanned MPD, property and evidence, chain of custody for all of the evidence related to item 9 or item 1/5. We would like to have that before any testing commences. We would also like clarification from the prosecution, which we still don't have, as to whether there are 3 slides or 1 slide, whether the 3 swabs still exist and can be tested or retested. And am I forgetting anything? That's what we would like. I think that we need a little bit more inquiry into the status of this evidence. 3 slides in a box. This what they have provided to us, it says that there's a white box. I just don't think that this is, I think we need more information. I think if the court is going to order this tape and any derivative evidence from the tape to be tested, we need to know what the chain of custody is, what it has been, where are these items now. They still haven't indicated where these items are at the Modesto Police Department.
I respectfully disagree because I think I just heard the prosecutor tell me at least some of the items are in freezer. But anything else you want to say in this mission?
I'm deeply concerned about the way this evidence was handled. If this is any indication of what's happening with the rest of the evidence, we're going to have a lot more litigation in the area.
All right, let's talk some more about this. I'm going to bring back in criminal defense attorney Bradford Cohen and retired Lieutenant Mike Gould. All right, let's kind of dig into this piece of duct tape. So it's found on Lacey's pants when her body washed ashore. This is along the San Francisco Bay back in April of 2003. So apparently it's about 15.5 inches in length. and it's something that was never been tested. Wondering if the water and the conditions could jeopardize what may be found on this. Let's talk a little bit about what it can reveal and can this really change things? Lieutenant Gould, your thoughts on whether the defense is going to get what they think they're going to get from this?
Yeah, Julie, so I'm not a DNA expert by any stretch of the imagination, but where I'm sitting right now, where you're sitting, there is DNA all over the place, hundreds of samples of DNA. But again, as I said earlier, there has to be a nexus. Whether water deteriorates it or not, I really don't know. But, I've worked on capital murder cases, and I understand the seriousness of it. And when science exonerates an innocent person, that is a miracle. It should be honored. This isn't the case for that, I don't think. I just don't think that with all the other circumstantial evidence. I think he's gotten great opportunity that the Innocent Project is even involved in this case. There's many other incarcerated people that doesn't get that chance with far less circumstantial evidence as this case has. So I just don't think this is the right case. The DNA, let's see what it reveals. I don't see it. The chain of custody is always something important. But 20 years ago, everything was completely different. They didn't have these databases, electronic databases. So again, that's not an excuse, but let's see where it goes. I don't buy it in this case.
Right, yeah, I don't either, Lieutenant. I mean, and Scott Peterson, to me, is a very lucky guy getting his death sentence overturned. And he's also a very determined guy, in my opinion. Remember, he made a bid for a new trial in 2022 when he was moved off of death row, and it was juror misconduct at that point. Juror misconduct, that's what should cause it. Now, I guess he's moving on. Bradford Cohen, do you think, are they grasping at straws here, or do you think there's some viability in this idea that maybe we can learn something earth-shattering from that piece of tape?
Well, first, I think in any capital case, you'll see multiple appeals. There's always multiple appeals. If it's juror misconduct, if it's something discovered, if it's something new, there's always appeals that come up. In this case, it's interesting because, like I said, we didn't have the same technology we had back then. And to answer your question, does water have an effect on DNA? Obviously, yes. Weather conditions always have an effect on DNA, and it can degrade it to a point where you can't test it. And back then, obviously, I think that it did degrade it to a point where it couldn't be tested, but now it can be. But to Lieutenant Gould's credit, he's absolutely right. If this comes back and it has nothing to do, it could be fish DNA. We don't know what kind of DNA it's going to bear. And if it has something that has absolutely nothing to do with the case, obviously, then they're dead in the water. If it's something else, if it is DNA from someone that was fishing in that area, if it's DNA from someone that, the decedent knew or was related to the decedent, or, something of that area, then it's going to be, I think that would be a very good cause to look at a new trial very hard and very intensely to see if that is something that would affect whether or not the jury would have come back a different way. Obviously, yes, there's a lot of other circumstantial evidence in this case. There's a lot of evidence that was pointing to him that is not this, but you can't overlook if this has something to do with the case and it's DNA that comes back that is related somehow to the decedent, then you have to look at a new trial intensely. And it could be that it's not grasping at straws. We just don't know sitting here. And the lieutenant is correct. Sitting here guessing and trying to figure out what it's going to be is very difficult until we actually see it. Now, when the DNA comes back, if it's a guy from the hardware store where this was bought, then it's not earth-shattering. If it is someone that was in the area, if it's someone that was related, if it's someone that she knew, to me, that would be a huge favor of the defense.
Yeah, great points you both are making. I want to know who's going to foot the bill for this. Who should foot the bill? Should it be Peterson's team or the state? We'll keep talking. I'm so glad you both are here. Attorney Bradford Cohen, Lieutenant Mike Gould, stand by, please.
Yep, that's the question that's gonna linger. Who should fit the bill for this one? I believe. This is just my opinion, but I believe Peterson's team should fit the bill for this one. If they want to prove this thing to the point where he should get a new trial, they ought to foot the bill. But that's just my opinion. We'll see what happens when that result comes in. All right. Next up, juries and deliberations in the synagogue leader murder trial. Michigan versus Michael Jackson Bolanos. So I won't go to the video on that one, but right now they say the Michigan jury is deliberating the fate of a Michigan man charged with the murder of community leader found dead outside her home. Michael Jackson Bolanos faces a potential sentence of life in prison if convicted of first-degree and premeditated murder of Samantha Wohl, who was killed on October 21st, 2023. Wohl, the president of the Isaac Agree downtown Detroit synagogue, was found dead outside of her Detroit home after she was stabbed multiple times. At the time of Jackson Bolanos' arrest, police said there was no indication that the murder was a result of a hate crime. Investigators said they believe Wohl was randomly targeted while the defendant was trying to break into vehicles. During police interrogation, Jackson Bolanos told officers that he had nothing to do with Wohl's murder. He took the stand in his defense during the trial, admitting that he lied to his girlfriend on October 21st when he told her that he was going for a walk when he was really planning to steal from unlocked vehicles. Jackson Bolanos said while he was doing that, he saw a dark figure lying outside, which he later realized was a dead body. Quote, "I was over there, going into motor vehicles, and I felt like if I had to call the police, I'd be incriminating myself." That's what he said while he was testifying. Jackson Bolanos' defense has tried to suggest that Wohl's ex-boyfriend may have been behind the brutal murder. That ex allegedly confessed to the killing before, later saying his memory had been altered by the use of drugs, including antidepressants, nerve treatments, and cannabis. Prosecutors previously said they found no proof to indicate that the ex-boyfriend was involved. So we wait while the jury's deliberating as far as is he guilty of murder or lesser charges. We'll wait and see. All right. All right, now here we go. Now it's time for the breaking news, for the news that I've been waiting to dish out all day. I've been talking about it. I teased it, and I've teased it, and I believe I've saved this one for last. In a shocking turn of events, the judge has dismissed the case against Alec Baldwin with prejudice on the third day of Baldwin's manslaughter trial. The judgment came after a tense day of scrutiny against the prosecutors, including the resignation of Special Prosecutor Erlinda Johnson and Special Prosecutor Carrie Morrissey taking the stand to defend her discovery in this case. After Judge Marlo Summer announced her decision to throw out Baldwin's involuntary manslaughter case, the courtroom erupted in a huge gasp, followed by tears, according to Court TV legal correspondent Matt Johnson, which you'll see in just a few minutes. Johnson sat in the courtroom on Friday when the decision was handed down. The judge's decision to dismiss the case with prejudice means that no future charges can be brought against Baldwin. Baldwin did not make a public statement, but left the courtroom holding his wife's hand with tears in his eyes. He can finally begin to move on from what his defense called a tragic mistake. Let's go to the courtroom right now. Let's hear from the Honorable Judge Mary Marlowe Summer, throwing the manslaughter case of Alec Baldwin.
Dismissal with prejudice is a very extreme sanction, and case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So, in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. State v. Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State v. Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted. Now, with respect to the jury, I don't imagine you all want to return on Monday. I will take care of the jury.
Thank you, Ron.
We are in recess. I'm not getting up. I'm going to...
Dismiss him, Judge. Dismiss him.
Go ahead.
Thank you all for your help.
Man, oh man. I didn't know how long that case was gonna go. I didn't know whether Alec Baldwin would testify or not. But after hearing Judge Marlowe Summer, that's it. Just like in another case we heard about earlier, with the judge dismissing the case with prejudice, there can be no further charges in the future against Alec Baldwin in regard to this case. A tragic accident, maybe. It may be a tragic accident, but you gotta also understand this fact. Alec Baldwin still has to live the rest of his life knowing that that he was holding the gun that fired and killed his friend Helena Hutchins. Did he pull the trigger? My opinion, I don't think so. But still, he has to live with that guilt. And trust me, living with that kind of guilt, that's hard enough for anybody on the one side who has been seated at the defendant's table being charged with involuntary manslaughter. To Alec Baldwin, I simply say this: thank the good Lord above that you had everything going for you, and you had some evidence that was supposed to have been shared and wasn't. My advice to you, my friend, go back doing your acting, but make sure what you're gonna do has no weapons around you. I don't care whether you're acting or even if you're acting as a producer. Make sure you have no weapons around you. Because the last thing you want to have happen is a replay of this. Just saying. So let's see. You know, I had every statement this week from Julie Grant ran for our opening statements, and it was all covering the Alec Baldwin case. But I'm not gonna do that. I'm not gonna cover all that, because now that case is over with, I'm gonna go to an editorial that I promised that I would, and I want to start it with this preface. Now, anybody who knows me knows I hate bullies. Can't stand them. Now that I got that part off my chest, I want to talk about a case that pretty much hasn't been talked about. I'm scrolling through my social media, preferably TikTok, and I hear all about this case of a 13-year-old in Mississippi who was relentlessly bullied to the point where she took her own life. Before I even call the young lady's name, I can say from my own personal experience, many moons ago I almost was her. Many moons ago, I almost was her. Aubrey Wyatt. From all I've seen, a bright, sweet young lady. Relentlessly bullied by to make light of a phrase, 4 mean girls. But that wasn't enough. You see, the mother of Aubrey Wyatt, Heather Wyatt, she's on social media. She wanted to speak out about bullying, about what happened to her daughter. But in a sense, Aubrey's being bullied a second time. How? They slap a gag order on Heather. They're trying, I'll tell you the they in a minute, but they are trying to silence Heather. Who am I referring to? I'm talking about the parents of the mean girls. And to make it worse, you have two in positions of authority. One, I can go ahead and update now, is no longer in that position of authority. That one is the lead bully's father, who is now the former superintendent of schools in Mississippi. But there is another one that's got a little power behind her. That would be her aunt. Her aunt is a district attorney. And you know what grinds my gears about the whole thing? What grinds my gears so is that these people make it so that bullying is okay. It doesn't matter what you look like, what your circumstances are, whatever. You can bully them and it's okay. It's all right. And then, if somebody tries to speak out about it, shut them up, and you can go ahead and bully them some more. She can't fight back now. She can't answer you back now. She can't do anything now. So as long as she's out, the girl's out the picture, and mom is shut up, you girls can go ahead and do whatever you want to. It's okay. You don't have to take accountability for it. I'm sick of it. Someday those girls are going to have to take accountability for it. I just got an update that there's an investigation already open in this case. And to the auntie who's also the district attorney, heads up, you can't defend them all. You cannot defend them all. Anyway, it makes no dang sense. Whether it's physical, digital, or whatever, it's still wrong. Bullying hurts. Take it from someone who knows best. And since I'm speaking out about bullying, I want to send a shout out to everyone in true crime, everyone in crime, and everywhere else in between. I'm sending a shout out to you all simply because enough is enough. If you're doing good on your respective channels in regard to true crime, great, keep it up. I got your back. If you're trying to blow up your channel by trying to put somebody else on blast, that's not good. Sure, your numbers are going up. But if you can sleep at night after doing all that, I feel bad for you. But like I said, but like I've been hearing, and I stand by it. Let us keep the name of Aubrey Wyatt and Heather Wyatt in our mouths, on our minds, and in our hearts. Because at some point, the next victim could be you. In one form or another. But I end this editorial like the great Richard N. Hughes of WPIX back when I was a kid. He would always end his editorials by asking the question, what's your opinion? We like to know. Alright guys, that's going to wrap it up for this edition of Bethea'S Byte Reloaded. I want to thank you all for watching, catching the replays and all. If you want to give your love to me, I have the free way right now is for you to like, share, subscribe, drop me a comment. Everything you do, I appreciate. If you want to help me financially, I appreciate that too. You can tip me at PayPal, EKB316, Cash App, $ EKB316, or Venmo, EB the Last Outlaw. And as my good friend Brittany would say, nothing obligated, it's always appreciated. Now, to get in contact with your boy, I'm on Facebook at Bethea'S Byte Reloaded. I'm on X, formerly known as Twitter, at EKB316. That's capitalized. Here on YouTube at Bethea'S Byte Reloaded. On Instagram at EKB316, and that one's lowercase, mind you. On TikTok at King of Hearts 316 2021, or you can email me. The address is kingofhearts316_09 at outlook.com. Alright? Alright, let's put this bow on it. This is the home for true crime news without the drama. Your opinions matter. Lively debates are encouraged. Your voice is heard, and above all else, it's justice served. Ladies and gentlemen, you know where you are. This is Bethea'S Byte, and it's reloaded. I am out of here. Thank you so much for joining me. Ernest Bethea, the Last Outlaw. Let's do this again next week, same time, same place. Until then, you all know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.